in today's episode of Exposing How the Corrupt System Works, I am requesting clarification from GARDAI as to why the recordings from the incident that occurred in February of 2024, why the recordings were denied initially, and why they were only released redacted after I was convicted, when those audio recordings pretty much had the entirety of the interaction. So I sent it to pretty much everybody. I had 2 FIOSR complaints on the matter. Of course, statutory bodies just always side with the bodies they're supposed to have oversight over. So I say, dear sirs, I refer to my subject access request reference SAR blah 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 and the disclosure issued by GARDAI Conviction on 30th of September 2025 after I was convicted, which has now been overturned without my having to set foot in a courtroom. I also note that issues arising from the handling, disclosure, and evidential treatment of the ECAS recordings form part of matters currently under consideration by FIOSRU under references and the 2 reference numbers. Thank you for the disclosure provided. I am writing to seek clarification regarding both the earlier refusal of access to the ECAS recordings and the subsequent redactions applied. Hold on just one moment, see if I can pause this. I'm new to all this, so okay. The kitties, that was Blackberry. I had to give them a little snacky turkey breast. All right. So, which I believe that were relevant to concerns regarding GARDAI conduct. Following refusal, I consider my ability to formulate and substantiate such concerns, that the complaint about the night I was arrested, that those concerns were materially impeded. A separate subject access request was subsequently made to GARDAI Conviction in June 2025, following my conviction in District Court Case number 2024-131-240, and during the course of live criminal proceedings, including Circuit Court Appeal number A2026-1502, arising from that matter. By that stage, the recordings had become directly relevant to my defense and appeal. The recordings constituted the only objective and contemporaneous evidence of nearly the entirety of the interactions between myself, the emergency call service, and GARDAI Conviction. The prosecution proceeded solely upon the accounts and notes of a single GARDAI witness. When the recordings were ultimately disclosed after conviction, they formed part of the broader evidential context available for consideration in the appeal proceedings. My appeal against conviction was subsequently allowed. I went to the loo, I came out, I asked a GARDAI standing there where my court would be, and he said, Ashley Denningham? I said, yes. He said, I've been told to tell you that your appeal was allowed. So I just walked in and walked out. At least I got to use the loo. I note that the disclosure letter states that certain data was redacted as the personal data of other individuals, and that further data was withheld pursuant to Section 94(3)A of the Data Protection Act 2018. That's when it was eventually disclosed after I was convicted. However, the letter does not identify which specific information was withheld under each basis. Accordingly, I would be grateful if you could clarify the following. Whether GARDAI Conviction, any member thereof, or any unit acting on its behalf objected to, declined to consent to, recommended against, requested, or otherwise influenced the refusal by ECAS/BT Communications to disclose the recordings in response to my February-March 2024 subject access request. The request was made in February. They said they needed GARDAI approval. Over the phone, they said typically a superintendent is the one that requests these from BT Communications, which is the ECAS service provider. But I said, how they're the ones that are in the wrong, so how am I supposed to get them to request it, and they had denied it. Apparently the SAR was more properly directed to GARDAI Conviction, but in such a circumstance, they're supposed to not just deny it and say, that they're supposed to deny it and say, oh no, you need to do the SAR with them. So I'm guessing that's probably what's going to come back as, but at the same time, they should have said, hey, you need to do the SAR with the guards, not just say, hey, no, we're not doing it. Because BT initially was saying, okay, we don't know if we can release it or not. We got to talk to the guards. GARDAI said no. So BT came back and said, no, we can't release it. And that was the end of that. Thought no complaint would be able to go forward because, who are they going to believe, a guard or myself, whose side are they on, So it says, if so, the legal basis relied on for the position at the time, why it was denied. I'm guessing they're going to say because it was the wrong. I should have more properly directed it to on GARDAI Síochána. But again, at the same time, they were supposed to provide that information and to facilitate my ability to do the SAR request. Just because you make it to the wrong person doesn't mean that, you can't make one. They're supposed to help you with that. Okay, so 3, whether the subsequent disclosure of the recordings in September 2025 after conviction reflected a change in circumstances, a change in legal assessment, or some other factor. 4, whether the removal of GARDAI and or emergency call taker voices from the disclosed audio was carried out on the basis that those voices constituted third-party personal data pursuant to Section 94.3a of the Data Protection Act 2018 or on some other legal basis. 5, which specific portions of the audio were redacted as third-party personal data and which, if any, were withheld pursuant to Section 94.3a. 6, whether consideration was given to releasing the recordings in unredacted form, having regard to the fact that the recordings related directly to the events which formed the basis of criminal proceedings against me and were therefore contemporaneous evidential material. 7, whether any written decision, memorandum, recommendation, policy document, legal advice, guidance, or record exists explaining the decision to redact the GARDAI and or call taker portions of the recordings. 8, please confirm whether the decision to redact the GARDAI and or call taker portions of the recordings was made in 2025 as part of the processing of the SAR, and if so, identify the date of the decision and office of decision maker responsible. 9, please confirm whether records exist concerning communications between GARDAI Síochána and BT Communication/ECAS relating to my February 2024 subject access request for recordings, and if so, please provide them. The incident was the night of the 22nd of February. I made the request, I believe it was the 26th. 10, please confirm whether records exist concerning communications, discussions, recommendations, directions, consultations, legal advice, or decision-making relating to the withholding, redaction, or disclosure of the ECAS recordings, and if so, please provide them. If no records exist, please expressly confirm that no records exist. Number 11, in circumstances where the recordings related directly to disputed facts in criminal proceedings and where the redacted speaker, B.M. Dunn, Brian Michael Dunn, Trim GARDAI Station, was the arresting guardee. Brian Dunn was the investigating guardee. Brian Dunn was the prosecuting witness. Brian Dunn was the sole prosecution witness. And Brian Dunn was the principal evidential source, the sole evidential source for the prosecution. Please explain the legal basis upon which his voice and statements were withheld or redacted from the recordings disclosed to me eventually. Please explain whether any consideration was given to the fact recordings constituted contemporaneous evidence, could corroborate, contradict, contextualize, or otherwise bear upon later testimony, witness testimony, and disputed facts. Please clarify whether they were considered necessary, notwithstanding the fact they concern interactions by GARDAI personnel in their official capacity during the performance of public functions rather than a private capacity. We weren't talking about his favorite place to have lunch, right? I understand if a GARDAI saying, hey, this is my favorite place to take the kids on a Saturday for, that should not be accessible to the public. But this is a legal interaction. I was trying to report an assault. He decided he wanted to arrest me. All of that, every word is directly relevant to the criminal matter, the offense I allegedly had committed, that he was charging me with. And please explain whether consideration was given to the fact one of the calls was made specifically for the purpose of creating an independent record of the interaction. It's allegedly when I was running up and down the street, I suppose. I just kind of walked to the back of the car because I was kind of trying to be a bit sneaky about it. I had walked to the back of the car and rang 999 and kind of had the phone down. So they didn't realize that they were being recorded at the time, which is why at the end of the recording, you can hear me say, "Don't arrest." And that's when it cuts off because that's when I was arrested. Please confirm that any consideration was given to the fact refusing to access the recordings in 2024 may have impaired my ability to formulate, pursue, or substantiate complaints concerning Mr. B.M. Dunn. Guessing his ma thought that she popped out a turd. So, bowel movement done. Can't name him that. How about Brian? Please explain whether the decision to redact GARDAI and or emergency call taker voices was taken before or after the consideration of the fact the recordings had become relevant to ongoing criminal proceedings, including the subsequent circuit court appeal, and whether any distinction was drawn between disclosure of personal data generally and disclosure of contemporaneous evidential material relevant to disputed facts in this proceedings. For the avoidance of doubt, I'm seeking clarification on the basis why it was they made the refusal in 2024 and why they could subsequently disclose them in redacted form in 2025, as they were directly relevant to live criminal proceedings and formed part of the contemporaneous evidence concerning the matters which I was arrested and prosecuted. I mean, one of the bases that they're relying upon is that they couldn't release it because it would impede an investigation or prosecution. Well, I mean, it's like Your Honor, this is detrimental to my case. I object. Why do you object? It's detrimental to my case. Well, we can't release the recordings because they show that Officer Dunn was in the wrong. So obviously that's not going to fly. Like that doesn't. You can't just say, oh no. This will impede a prosecution because if we release these recordings, then we can't convict her. So yeah, of course we can't release the recordings because then we can't have her convicted. We can't have objective evidence. I mean, that appears to be the crack there. And then I ask here, if any records are withheld or redacted, please identify specific statutory provisions relied upon. And where possible, I request partial access. And I also ask them to confirm if no records exist. So, yeah, this is trying to get through this corruption. I'm not the only one, but I'm posting these in their entirety because anyone else going through the same sort of thing, maybe this can give them a bit of help because there's no way that I could afford to hire a solicitor, and that's what they're counting on. You give 150 quid or 250 quid or what have you to the Red Door Project, and there you go. Just take a caution, get out the door, And anything that the GARDAI do wrong, if they convict you, then FIOSOR says, well, the case was fully heard in court. No, it wasn't. I'm used to upper courts where you go in 1,000,000 times before anything actually happens. I was told I was doing court in the day. I go in there and I tell the solicitor again what happened. Okay. And then I got on the stand and I hear what's going on. I'm like, wait, hold on. Okay. Now if there's a hearing today and it is based on like fact or like what the heck's going on? I'm too naive and trustworthy with them. I mean, I should know better after what happened in America, but